Judgment in the matter of Stoker versus Stoker.
Lord Kerr will explain the decision of the court.
The marriage of Ronald and Nicola Stoker ended in disharmony in 2010. After their divorce, Mr. Stoker formed a new relationship. And in December 2012, Mrs. Stoker posted messages on the Facebook page of Mr. Stoker's new partner. In these, she said that during their marriage, Mr. Stoker had tried to strangle her and that he had to be removed from the matrimonial home following a number of threats that he'd made, that there were some gun issues, and that the police believed that he had broken the terms of a non-molestation order. This appeal is about whether the statements which Mrs. Stoker made were defamatory of Mr. Stoker. He took proceedings against his former wife, claiming that she had defamed him. In particular, he said that the words "he tried to strangle me" meant that he had tried to kill her. He also alleged that the suggestions that he had uttered threats and breached a non-molestation order were defamatory, inasmuch as they implied that he was a dangerous and thoroughly disreputable man. The judge who heard the case approached the question whether the words "tried to strangle me" defamed Mr. Stoker by considering the dictionary meanings of the verb to strangle. There were two possible meanings. First, to kill by external compression of the throat, and second, to constrict the neck or throat painfully. In the judge's estimation, the fact that Mrs. Stoker had said that her husband tried to strangle her precluded the possibility of her statement being taken to mean that he had constricted her neck painfully. It had to be construed, he held, therefore, as meaning that he had tried to kill her. On the meaning to be attributed to the statements that Mr. Stoker had been arrested, had gun issues, and was believed by police to be in breach of a non-molestation order, the judge found that they meant that he was a man who was dangerous to any woman with whom he had lived or might live, and he therefore found in Mr. Stoker's favour. Mrs. Stoker had claimed that her statements were substantially true, and that she was therefore entitled to rely on the defence of justification. The judge dismissed that defence. He said that Mrs. Stoker had not met the sting of her Facebook postings, which was that her husband was a dangerous man. Mrs. Stoker appealed. The Court of Appeal dismissed her appeal. It found that although the use of dictionary definitions did not, as the court put it, form part of the process of determining the natural and ordinary meaning of words, the judge had merely used the dictionary definitions as a check, and that counsel had been given the chance to make submissions on the definition. So, in the court's estimation, no harm had been done. On the meaning given by the judge to the statements concerning threats, gun issues, and breach of the non-molestation order, the Court of Appeal considered, as indeed had the judge, that that meaning was dependent, to some extent at least, on the correctness of the trial judge's conclusion as to the meaning to be given to the words "tried to strangle me." In this context, it's important, for reasons that I will explain in a moment, that Mr. Stoker, that the meaning which the judge had given to these words, that Mr. Stoker was a man who was dangerous to any woman with whom he had lived or might live, that meaning was not one which had been advanced on Mr. Stoker's behalf. On the question of justification, it had been argued by Mrs. Stoker's lawyers that the trial judge had failed to take into account Section 5 of the Defamation Act 1952, which in broad terms provides that in an action for libel or slander in relation to the words containing two or more meanings adverse to the person of whom they are spoken or written, a defence of justification should not fail just because some of the words have not been shown to be true. when other charges against the person said to have been defamed had been established as true, and when what remains did not materially injure the person's reputation. The Court of Appeal held that because the truth of the charge of having tried to kill Mr. Stocker had not been shown to be true, indeed Mrs. Stocker had not attempted to prove it, because she said that that was not what her Facebook posting meant. In any event, the Court of Appeal decided that Section 5 could not be prayed in her aid. Now, Mrs. Stocker appealed to this court, and the Supreme Court unanimously allows her appeal. After a close and careful examination of the transcript of the hearing before the trial judge, it has been concluded that he did not merely use dictionary definitions as a check on the meaning to be given to the words "he tried to strangle me." The judge had consulted the dictionary before the trial began and commended consideration of it to counsel. It was therefore plain that, far from using the definitions as a check, what the judge did was to regard the two definitions as the only possible meanings which he could consider, or at the very least, the starting point for his analysis, rather than as a cross-check or confirmation of the correct approach. In the Supreme Court's opinion, this illustrates the danger of the use of dictionary definitions to provide a guide to the meaning of an alleged defamatory statement. That meaning is to be determined according to how it would be understood by the ordinary, reasonable reader. It's not fixed by technical, linguistically precise dictionary definitions divorced from the context in which the statement was made. Moreover, once the verb strangle is removed from its context and given only two possible meanings before it's reconnected to the word tried, the chances of a strained meaning are increased. The words must be taken together so as to determine what the reasonable reader would understand them to mean. The context in which the alleged defamatory statements were made is also of supreme importance. The fact that this was a Facebook post is critical. The advent of the 21st century has brought with it a new class of reader, the social media user. The judge tasked with deciding how a Facebook post or a tweet on Twitter would be interpreted by a social media user must keep in mind the way in which such postings and tweets are made and read. This is necessary in order to understand how a typical, that is, an ordinary reasonable reader would interpret the message. And that search should reflect the circumstance that this is a casual medium. It is in the nature of conversation rather than carefully chosen expression, and that it is preeminently one in which the reader reads and passes on. This court has therefore decided that it was a legal error to rely on dictionary definitions, and that the judge's decision as to the meaning of the Facebook post cannot stand. In those circumstances, it is for this court to determine what the meaning of the words "he tried to strangle me" was. We have concluded that knowing that Mrs. Stocker was alive, an ordinary reader of Facebook would have interpreted those words to mean that Mr. Stocker had grasped his wife by the throat and applied force to her neck, rather than that he had tried to kill her. Mr. Stocker unquestionably did apply force to Mrs. Stocker's neck. Red marks were still visible on her neck when police officers arrived at their home some 2 hours after the incident. In light of this conclusion, Section 5 of the Defamation Act assumes obvious importance. Since the force applied by Mr. Stocker to his wife's neck was sufficient to cause reddening of the skin, and since it was not disputed that he had breached a non-molestation order, it might be considered by most people that these were sufficient to establish that he was a dangerous and disreputable man, which is, of course, the justification that Mrs. Stocker had sought to establish. But once the question of trying to kill is removed from the equation, there is no warrant for the judge's conclusion that her words in relation to threats, gun issues, and the non-molestation order should be taken to mean that he represented a danger to any woman with whom he might live, a meaning which, as I have said, Mr. Stocker did not advance. In any event, Even if all Mrs. Stocker's accusations were considered not to have been established to the letter, there is more than enough to satisfy the provision in Section 5 of the 1952 Act that her defence of justification should not fail by reason only that the truth of every charge is not proved, having regard to the truth of what has been proved. This court therefore allows the appeal, and subject to any submissions that the parties might wish to make, orders that the costs of the hearing before this court and the courts below be borne by Mr. Stocker.